on those as far as recommending approval, they would then move over to the City Council for additional readings and public hearings. I did want to point out that because of last-minute changes to ordinance number 2026-0-3, because there was additional language added, we had to change the agenda for item 3. Because of that small change, and we couldn't get the agenda out in time, we're going to ask that that item be tabled and re-advertised, but I will explain the small changes that were made for clarification purposes. So with that said, I prepared a notebook in front of you with all the draft ordinances. You have seen these ordinances before at the various meetings in the past. I'll summarize those, and I will not read the ordinance itself in its entirety, but if you have any questions, I'm happy to go over those. So the first ordinance, 2026-0-1, the PRD overlay zoning to apply to a city-owned 74-plus acre tract. It's an ordinance of the Mayor and City Council of Pocomoke City amending official city zoning map for Lot 1, Map 92, Grid 2, Parcel 210, consisting of 74.17 acres along Old Virginia Road, said property owned by the city, to amend the zoning on the property from M1 Industrial and B2 General Business to Planned Redevelopment District, referred to as PRD floating zone, as made reference to by Chapter 230 of the Zoning Code, Article 7, Sections 230-55 through 230-60. So under the first yellow tab, you'll see the actual ordinance and 4 attachments. One references the SSTAT listing for the property, the State Department of Taxation information. Attachment 2 refers to the map itself that's consistent with the SSTAT information. Attachment 3 is the survey that was used for the annexation of the property on Lot 1, and attachment 4 shows the existing zoning patterns consisting of the M1 and B2. So this was initiated at the request of the Mayor and City Council. It was brought to the Planning Commission, I think, within the last 2 months. There was an endorsement to move forward with the public hearing on this. So with that, I'll answer any questions if you have, or open it up for the public hearing for public comment.
So there's no changes from the original from when we first?
No changes. I think Ms. Witz had made a point that normally this is tied to a master concept plan that's submitted along with the zoning change, but I believe the City Council and the Mayor wanted to initiate the zoning anyhow on this property with the hope that a developer will submit something at a later date, possibly tied and linked to a PRD overlay zoning, and thus save time and money, although we have not received any formal concept plans at all at this point. So.
Just to make sure I'm right, this is over there by where the old Bonanza was, right? This is that lot where old Bonanza was, right? Where the old Bonanza, Plaza Tapatia, is that that's the property we were talking about? That area? There's the old buildings in there. It used to be the Plaza Tapatia.
The old Bonanza, that was then,
Yeah, well, I believe that's their area you're talking about.
yeah.
Right next to Gibbons Automotive, as far as fronting Old Ocean City, or the Highway 13, and it's north of the Scrimmager property, as I refer to, that's been platted out as the access road between Old Virginia Road and Highway 13.
Yeah, this is all the line I'm talking about.
All right, so at this time, we'll open it up to the public hearing. Is there anyone here in the audience or anyone that wants to speak to this ordinance on the 74 acre on the rezoning? Anyone? Do I have a motion to close the public hearing?
Make a motion to close it?
Second? All in favor?
Aye.
So I believe that it's appropriate, Madam Chair, to actually make a motion to move forward recommended zoning change and then forward it on to the city council for further action.
Justin, do you want to reword that?
I'm gonna try to. I'll make a motion to move forward as plan is and close the public hearing as council, or not council, city has recommended.
Just forward it to council.
Yes.
I second. All in favor?
Aye.
Okay, Mr. Brandon, we're going to move on to item number 2, the ordinance number 20260-2, an ordinance to amend the city code for the building construction, building permits, timeframe.
This is an ordinance to amend City Code Chapter 101, Building Construction, Article 1, Building Permits, and Chapter 230, City Zoning Code, Article 15, Administration and Enforcement, for the purpose of clarifying and making uniform the time limits and expiration of building and zoning applications, and to further establish time limits on permits that are not kept active or when they have deemed to have expired, and to authorize the granting of time extensions upon showing justifiable cause. So in your package, the changes are crossed out and the new language is shown in capital letters. And essentially the language reads for both of those sections, it reads as follows. An application for a permit for any proposed work shall be deemed to have been abandoned 180 days after the date of filing, unless such application has been pursued in good faith or a permit has been issued, except that the building official is authorized to grant one or more extensions of time for additional periods not exceeding 180 days each. The extension shall be requested in writing and justifiable cause demonstrated. It goes on to further read, every permit issued shall become invalid unless the work authorized by such permit is commenced within 180 days after its issuance or after commencement of work, if more than 180 days pass between inspections. The building official is authorized to grant in writing one or more extensions of time for periods not more than 180 days. The extension requests must be requested in writing and justifiable cause demonstrated. So this came about because the existing language doesn't necessarily set a time limit as to how long a permit can remain open. And there have been past instances where owners, builders have just delayed acting on their building and making those necessary improvements according to the permit. A lot of times they may involve code violations, and as a result we have potentially a dilapidated building that's just sitting there for extended periods of time. So this will address that situation. They may have to be charged additional permits and renew the permit, and there's a time limit as to when that permit expires. So this clarifies that language. It's consistent with language found in the International Residential Code and International Building Code, which are obligated to follow. So this makes it uniform in both zoning permits and building permits.
I'm going to go ahead and open up the public hearing. Is there anyone here that wants to address or have anything to say on this particular ordinance to change the timeframes on any kind of construction permits? Anyone? Do I have a motion to close the public hearing?
Make a motion to close the public hearing and accept ordinance number 2026-02 and according to as staff has permitted it in front of us.
All in favor?
Aye.
Unanimous? Did you make a motion to move it forward?
To close the public hearing and
Okay.
accept it as is, yeah.
That's you did everything? You were like one step ahead with my.
I tried to be a little more appropriate that time.
Okay, item number 3, ordinance number 2026-0-3. Mr. Brandweed?
This is an ordinance of the Mayor and City Council of Pocomoke City to amend the city's zoning code with revisions to amend Chapter 230, Article 2, terminology Article 5, the R1 Residence District, Section 230-35 Accessory Uses, E. Article 6, R-2 Residence District, Section 230-42 Accessory Uses, E. And Article 7, R3 Multifamily District, Section 230-49 Accessory Uses, E, for the purposes of eliminating the keeping of lodgers, roomers, and boarders by a resident family in residential zoning districts. Again, as I mentioned at the beginning of the meeting, because we had to reinsert some language in the actual agenda, we are recommending that this be tabled and re-advertised and have an additional public hearing at the next meeting. The changes were very minor at the recommendation of our legal attorney. She recommended that we add definitions of roomer, boarder. Those are shown in italics in the Article 2 terminology on page, starting with page 5, we have also the definition of family and housekeeping unit added. In addition, then on page 6, you have the definition of lodger. And on page 8, you have the definition of roomer and boarder. Those were the 3 definitions added. Then within each of the R districts, under the accessory uses, the item E, which states the keeping of not more than 1 roomer or boarder by a resident family, and that's both in the R1 and R2 zoning district, is struck out. And then we added the language, the keeping of lodgers, roomers, or boarders in the R1 district is prohibited. And that language also is found in the R2 section. The R3 section actually goes on to allow 2 roomers or boarders in the R3 multifamily district. Again, that is struck out under the accessory use clause, and the language of the keeping of lodgers, roomers, or boarders in the R1 district is prohibited. So that's the gist of the ordinance itself. But again, because we had to make a last-minute agenda change that shows that addition, we're then asking this to be tabled, re-advertised, and rescheduled for a public hearing.
We need to make a motion to table this.
Okay, I see.
I'll make a motion to table this ordinance number 2026-03 to advertise for a new public hearing as staff has recommended.
All in favor?
Aye.
When will you, within the next couple of business days, put this in the paper?
And we have to re-advertise. Yeah, we can do that. Depending on our meeting date.
Or we have July?
I don't have the August meeting date in front of me.
Madam Chair, if I may, what I'd like to do right now, if there's a motion and the commission's interested in doing it, is review the changes and make sure that they comport with what the commission's ideas and concerns were. Because if there needs to be other changes, now would be the time to discuss them so they can.
So we either want to do the work session prior, or we can put it on the agenda for the next meeting, or?
I'm asking that that discussion be held right now. I mean, I don't think there's any issue with just having a discussion,
Oh, okay.
reviewing the changes.
If that would expedite
Yeah,
things,
I
then,
think that'd be fine.
since it's, and you feel that way because it's a minor change per se.
I think it's appropriate just to alter the agenda slightly so we can have a discussion on the changes so far, just to keep things moving.
Okay. Okay. I have no problem with the changes what I should say, the changes that you made in the wordage.
Ms. Witch, would you want to upon some of the basis for some of the definitions? I know you and I shared some research, largely from Salisbury's attempt to regulate or limit this type of situation.
So, if I understand the situation and what we're trying to address, you know, I believe there's somebody who's renting a room to one person and that's causing issues. I think that was the catalyst for these changes, if I understand that correctly. The changes that have been made in this, address that situation, at least that's what the intent is, but the intent also is to make sure that we're not preventing people from just, you know, having a roommate, assuming you're living together as a housekeeping unit, meaning you're sharing household duties and chores and things of that nature. That was my understanding, that was kind of what the intention was, and so that, I believe, addresses that. The definition is family or housekeeping unit because obviously the way people live and cohabitate isn't just families in the traditional sense. So that we try to account for that as well. It allows for, you know, people who are living together for assisted living purposes, healthcare reasons, things like that. I think one of the concerns that was brought up was like foreign exchange students. I thought that was like an interesting and specific thing, but I believe that this definition would take care of that, and it wouldn't accidentally eliminate the ability to have a foreign exchange student. So that's the way that it was written. So, yeah,
Well, this was related to like rent and leasing a room, correct?
I'm sorry?
This was related to like renting or leasing a room in a single family dwelling. I don't think a foreign exchange student would fall in that category because generally they don't pay rent.
Right, I don't think that they would either, and I don't know what kind of compensation like a host family gets for that, if anything, so what I'm saying is we could have accidentally written this in a way that would exclude things like that, rather than intending to, so. But the way that this is written now, with these new changes, I think that it wouldn't exclude situations like that.
But this also covers the situation we had on Sixth Street where they were a single-family home and they were openly renting room by room by
Right,
room.
exactly.
As a boarding house.
Right, and that's what these changes are here to
We covered
eliminate
that as well, because there
situations
was
like that.
3 or 4 of those
Right.
that have since gone away.
I do know another concern of ours was family members, like having family members come back and charging rent like that. Is that like kind of excluding that as well in the wording?
No.
Or is
it
that
wouldn't-
including that?
It wouldn't, the way now that situation, especially if they're living as a group, as a unit, and you're not just renting out your room to somebody.
Right.
Now, what I am seeing in here that I think has to change is we have a definition for family, and then we have a definition for family or housekeeping unit. So it might make sense to strike the old definition of family if we're gonna use this definition of family or housekeeping unit.
What page is that on?
It's on page 5.
Page back on 5.
For the sake of clarity, I'll read both, that's helpful. So the existing definition of family is a person living alone or 2 or more persons living together as a single housekeeping unit, but not including a group of persons occupying a boarding house, lodging house, hotel, dormitory, institution, group home, halfway house, rehabilitation house, or similar use. So the proposed definition is family or housekeeping unit. Family, I repeated that in that text, 2 or more persons who are related by blood, marriage, adoption, guardianship, or other duly authorized custodial relationship living together as a single housekeeping group in a dwelling unit. Under item 1, a family or housekeeping unit may include persons who provide health care or assisted living services to a member of the family or housekeeping unit that are essential to the health, safety, or general well-being of the member. Item 2, a family or housekeeping unit may not include or consist of A, occupants of a rooming house or boarding house, B, persons whose association as a group is temporary or seasonal in nature, and C, persons living in a group arrangement as a result of criminal conduct. So having both definitions is redundant, and we can probably strike the existing one, is what I'm hearing.
Is this correct, Erica?
That's, yes, I think it's gonna get confusing to have both.
So just
family.
strike out the original family one and then pull in the new definition as family.
Yeah.
I think that would be more clear.
So we'd be replacing family with family or housekeeping unit.
Yes.
Cool. I don't see any issues with it then, if we just do it that way.
Okay. All right, now are we ready to make a motion with the adjusted language?
Let's see. I'll make a motion to table this for a new public hearing. And under the circumstances of striking out the original family definition and replacing it with the new definition provided by staff.
A second. All in favor?
Aye.
Aye. Unanimous? Okay, on to item number 4, the ordinance number 2026-04, in regards to the critical, infamous,
Critical area.
Mr. Brandweed?
This is an ordinance of the mayor and city council to create chapter 206, which is a new chapter in the Pocomoke City Code, although it's a zoning-related ordinance, in order to adopt critical area zoning regulations entitled Pocomoke City Critical Area Program, and to adopt a supplemental zoning map entitled Chesapeake Bay Critical Area Overlay District Map, to implement regulations required by the Natural Resources article of the Maryland Annotated Code to further protect the waters of the state. As we mentioned in previous discussions on this, much of the city has been exempted from the critical area, and that dates all the way back to 1988 when they were first proposing the program, and a number of other cities were in a similar situation, such as Cambridge, where much of the older part of the city was considered already developed and therefore exempt. We had a similar situation. But we received draft regulations back late December, early January, February, and were asked to proceed with review and modifications as it fits our particular situation. We have gone through the regulations. They're basically consistent with state guidelines and most other critical area regulations adopted by other cities. The map, as shown in the handout, identifies the exempt area and identifies the area around the Winter Quarters Golf Course as being a resource conservation area. The only area, as I mentioned in our previous discussion, that's affected somewhat is the area, or the vacant lots around Newtown Boulevard, which could be asked to comply with new regulations as far as runoff controls, possibly a forest mitigation plan if they develop. The actual boundary, which shows in green, was enlarged a little bit based on new mapping information. So it actually crosses Old Snow Hill Road and picks up 3 or 4 businesses such as Taylor Bank, the Store and Lock facility, and a little portion of the Walmart property. None of those businesses are really affected because they're already developed. So unless they go to expand, and there's very little room on those parcels to expand anyway, they're really not affected by the regulations. So beyond that, there's little in the way of impact to the city unless The resource conservation area around the golf course is slightly developed. There are a couple parcels on the backside of Winter Quarters Drive extended out to the log cabin that possibly are impacted if they build. There's no vacant lots there, but if they build an accessory building, they could be impacted by further review of the critical area. So beyond that, there should be little impact to the city. It's a mandate by the state that we have to adopt these. It's a complicated ordinance to administer. Frankly, if we do get an application, we would rely heavily on state guidance and the Critical Area Commission, to help us work through the reviews. And you have to have potentially mitigation plans and forest conservation plans, reforested area plans resubmitted and so forth. I think that pretty well covers it. This would then go on to City Council for first reading, second reading, public hearing, and if it's adopted, that then goes back to the Critical Area Commission for final review, and they may have some final say-so over its content. But the CAC, the Critical Area Commission, actually hired a consultant, Michael Grassman, if I'm saying that correctly, and he assisted with the preparation of this document. So he was hired by the Critical Area Commission to work up this document and get it in front of the cities and towns that needed to have it adopted. So he was instrumental in preparing it. So it should be consistent with anything that the Critical Area Commission requires. There shouldn't be any issues for their review after City Council adopts it. So that's where it's at. We are asking the Planning Commission to move forward with the recommendation of approval and send it on to City Council for their consideration.
Okay, I'm going to go ahead and open the public hearing up on the proposed critical area. Is there anyone here? Anyone have anything to say further, for or against? Okay, do I have a motion to close the public hearing?
Make a motion to close the public hearing.
Second, all in favor?
Second.
Aye. All in favor, aye. Okay. Okay, any further discussion from the commission members in moving this forward as a recommendation to the mayor and council?
Doesn't seem like we really have much of a option on this one, so.
Had we ever had the critical area maps prior than the mayor and council approved? I mean, what was in place prior to this? Anything?
As far as any applications for review, no,
Yeah.
not that I'm aware of. Although I did read where Hardwire, when they built their first building, were asked to comply, even though they were considered in an exempt area. But apparently their plans went through and there were no issues, but
Yeah, that wouldn't be surprising.
it was a voluntary, I think, commission, a committal to comply with critical area requirements, even though they were considered exempt. So that's the only one I remember seeing in some of the minutes.
Okay.
Any other suggestions? How you feel?
Do you have a motion? I will go ahead and make a motion.
I'll make a motion to accept ordinance number 2026-04 as the state has recommended us to move forward.
All in favor?
Aye.
All opposed? Is that motion sufficient? Or do we, for this, do we need it a little more in depth before we go any further?
I think it's sufficient.
Okay.
This is an ordinance of the Mayor and City Council of Pocomoke City to amend the city zoning code by adopting a new Article 12 entitled Urban Design Standards and a new Section 230-82 entitled Architectural Design Minimum Requirement for Neighborhood Compatibility. As we've discussed in the past, this was largely brought about by the state law that was passed, House Bill 538, that was signed into law by Governor Moore on April 25th of 2024, and it became effective this January 2025. This bill was to provide an additional tool which Maryland can use to solve the state's affordability housing problem. So what it did was mandate that manufactured and modular homes be allowed in all residential zoning districts. However, the jurisdictions can require certain minimum design standards that they can apply to these homes as they're put in the various neighborhoods in the residential districts. That's what this ordinance hopes to accomplish, is to provide a review process for when new homes are built, that we have a chance to evaluate them for consistency within the neighborhood that they're placed. And this has come up on 2 or 3 occasions in the past 2 years where manufactured homes have been installed in the city in areas that would be considered part of our nationally recognized historic district. We're having one right now built in a historic district just down on the Winter Quarters Drive, and we were fortunately able to convince the builder to provide something that was consistent in the neighborhood in that particular situation. He voluntarily agreed to do it. His first submission, I believe, was a 1-story, fairly flat roof design that would not have been appropriate in that particular historic area. So regardless, we did borrow information and an ordinance from the city of Cambridge that provides a neighborhood compatibility review process. Basically, it would allow staff and require the builder to do a survey of neighborhood conditions, submit the results of that survey back to staff for further evaluation to verify it's consistent with the neighborhood conditions. And the worksheet is actually provided as Exhibit A. So a builder would have to then evaluate, neighborhood conditions across the street or adjacent to the property, evaluate such things as the age of the neighborhood's structures, the structures in the neighborhood, their age. They would evaluate lot size, setbacks, the size of the building, the land use patterns in the area, the number of stories, parking situation, parking access, the architectural style of the neighborhood, and other architectural features such as porches, dormers, windows, chimneys, and other related items. It would also evaluate roof design, such as if it's a flat roof, hip roof, gable roof, etc. So they would submit this back to staff, we would evaluate it, the staff and the city manager would review it, and if we believe it's consistent, we would allow it to move forward with the building permit. If it's denied, they can further appeal that then to the appropriate agency. So we think this is necessary because of the state mandate. As you all are aware, we do not have local historic preservation district standards, and this was actually an idea that was discussed by City Council to move forward with that, and that's not materialized at this point. But in lieu of having a local historic preservation commission and standards, we think this will help protect our historic district, which we have almost 700 properties recognized in a national historic district in the city, which is a very large district. So we think this is a good solution, a good alternative to having historic preservation standards and a historic preservation commission.
I'm going to go ahead and open up the public hearing for this particular ordinance of 2026-05 on the compatibility, zoning change and urban design standards. Is there anyone here that has anything to say or would like to join the conversation? Anyone? Okay. Motion to close.
Make a motion to close the public hearing.
I second. All in favor?
Aye.
Is there any discussion on the commission, before we go to a vote on the compatibility ordinance? I think it's obviously everything that we've gone over for a while now, on the same issues. And it's long overdue.
What?
It's long overdue.
Yeah, I don't see anything,
Do we have a motion to move this forward to?
I don't see anything I disagree with. So, I don't see anything I disagree with.
No, it,
Like you said, we've been talking about this for a while, so.
yeah. It seems to be getting progressively worse as each one comes along. You know, winter quarters was a perfect example.
Any other suggestions from anyone? Or?
We close the public hearing, we're just waiting for, I'm just waiting for a motion.
All right.
Remember that manufactured home? The issues we had with that? We knew that was coming, right? Just on the modular and manufactured homes and that change.
Yes, we've been aware of it for a year now.
Yeah. So we need to get this moving forward.
Well, I'll make a motion to accept ordinance number 2026-05.
On the urban design standards.
Yeah, I can see this. I'll start over on that if you want. I'll make a motion to accept ordinance number 2026-05, an ordinance of the mayor and city council to amend the city's zoning code by adopting a new Article 7 entitled Urban Design Standards and new Section 230-82 entitled Architectural Design Minimum Requirements for the new construction to ensure neighborhood compatibility.
Is there a second? All in favor?
Aye.
All opposed? Okay, moving on to ordinance number 2026-0-06, and this is item number 6 on the agenda. To amend chapter 230 on the zoning code.
Yeah, the final ordinance before us is an ordinance to amend Chapter 230 zoning of the city's Code of Ordinances and to adopt as part of Article 12 Urban Design Guidelines by adding Section 230-83 sign standards as applied to murals and signage within the city of Pocomoke City. This came about because there were some really great murals recently painted on some of our buildings, and it was felt that we should have some additional guidelines moving forward with new murals to at least have some oversight and say so as far as the design and quality and location, et cetera. So this ordinance would be considered a signage type ordinance, and it goes on to provide the purpose, definitions, the theme, location, design, material, and the process itself for reviewing murals. And basically it starts with staff review, and if the application is determined that it's necessary to be referred to the Planning Commission, they then can act on it as well. It also addresses preservation and maintenance, and possibly when a mural is not considered a mural and it could be considered graffiti. So this has been discussed before as well, and this would be, again, part of the new urban design chapter that we're asking to be created, and an element of that. The urban design chapter is something that came out as a recommendation of the 2014 comprehensive plan, where it was felt that additional urban design standards were needed for the community. So this somewhat meets, I think, the 2014 recommendation, and can be built upon, such as if other things come up, such as requiring street trees in new subdivisions, for example. So there's other things of urban design nature that can be added at a later date, but right now, the neighborhood compatibility and the mural standards would be the two sections to be added.
Okay. I'm going to go ahead and open the public hearing for ordinance number 2026-0-06 on the urban design ordinance. Is there anyone here that would like to say anything? Speak towards the ordinance? Okay. Motion to close?
I'll make a motion to close the public hearing on ordinance number 2026-006.
All in favor?
Aye.
All opposed? In my opinion, we've gone over this with a fine tooth comb for some time now.
I do have two questions, though. So, we all know that I have a mural on the side of my building, right? So, in the definition of graffiti, it is including sprayed or painted. So, that mural was all spray painted. So, this would exclude that mural out of that definition of an actual mural. And would put it under the category of graffiti. Correct?
Well, for one thing, it's grandfathered in.
I understand that, but for future reference, like, if they were to do that same type of mural again, this would exclude them from being able to do that, correct?
I don't interpret it that way.
I
If
don't
it's,
either.
if it's unauthorized and not reviewed and approved
But
prior
if you're
to
looking
that,
at it, it says the definition of a mural shall not include graffiti. Now, graffiti means unauthorized inscription, and this includes sprayed and painted.
The operative word is unauthorized for the graffiti. So you have to go, so if, when you're doing the plans for your building, you've got the artist hired, he shows you the mock-up, you take the mock-up, you follow the procedure in here, go through the process, the planning commission looks
Okay.
at it, approves it, then he puts it on the building.
Understood.
Yeah.
Which means if you go out with your spray paint and you start tagging these different walls, that's graffiti.
Unauthorized inscription. Okay,
Are we good?
yeah. Just wanted to make sure, clarify it.
All right, so do we have a motion in accepting the ordinance to adopt the urban design standard and forward it on to mayor and council?
I make a motion to accept ordinance number 2026-006, on an ordinance of the mayor and city council, Pocomoke City, to amend chapter 230 zoning code of the city's code of ordinance and to adopt as part of the new article 7 urban design standards by adding 2030.83 sign standards as applied to murals and signage within the city of Pocomoke City.
Second? All in favor? All in favor?
Aye.
All opposed? Okay. Unanimous. Moving on to new business. Mr. Brandon Reed, preliminary final plan and subdivision plat for the lands of Great Holland, parcel A at the Oxford Court.
no new information on that. As you'll recall, we did recommend approval of the preliminary plan to be brought back as a final plan with modifications. At this point, we haven't received any new information. I think there was some movement to ask the city to take over the management of the stormwater pond on that particular site. I have not received an update on that, where that's at. But so at this point, we're waiting on a new plat to be reviewed by the Planning Commission.
Moving on to item number 8, petition and master plan concept plan. Referral received from the city council, request for a zoning map amendment for the redevelopment of parcel 1606 Old Virginia Road, consisting of 25,448 square feet, to construct 15 apartments. Zoning map amendment request from B2 general business to PRD overlay zone. Mr. Brandon.
Yes, this is a follow-up, as a referral from City Council, where the City Council received the petition, a concept plan, master plan, and proof of ownership for this particular development at parcel 1606 Old Virginia Road. So this is referring the matter back to the Planning Commission for further consideration, review, and recommendation. So I have updated my staff report from June 19th, updated a few days ago. We did receive an email from Kevin Lynch, who's superintendent of the road division for Worcester County. He became aware of this development, and he passed on some comments by email to me, and I'll review those comments on page 2 of the staff report. First one was, they will need to reach out to us in reference to the design and specs of their entrance along Old Virginia Road for our approval. I want to make sure all shrubs, sidewalks are not within our right-of-way along Old Virginia Road, so that any maintenance will be up to the HOA, rental company, etc. 3, with the entrance being so close to Market Street, I have concerns with congestion at that intersection. 4, with 15 units and only 27 parking spaces, that is less than 2 spots per unit. I have some concerns that there won't be enough parking, especially if families were to move in and have more than one car. So prior to Planning Commission approval, we do recommend the applicants receive additional feedback and clearance from the Worcester County Roads Division regarding this site plan, specifically as to the points that he raises, as I mentioned in the email that I received. The congestion along Old Virginia Road, from staff's perspective and from what we have heard from other residents and citizens, is that during school pickup and drop-off hours, it is a little bit of a problem. So there may be some thought given to how to address that situation, such as maybe only a right turn only out of the development during school hours or delivery hours. I'm not quite sure how best to handle it, but that's one idea. On that point, it's not inconceivable that that particular road may have to be widened at some point, and we understand there are efforts by the school district to look at pedestrian improvements, possibly in front of high school and at the Cedar Street, Old Virginia Road intersection. And we're not sure how and if that, when that effort's going to materialize. The city has set aside some money apparently for some sidewalk improvements. I'm not sure what the details and the plans are at this point for that money that may have been budgeted. But so there could be other resources and other plans in the works to make some improvements, because if you're familiar with that stretch, the sidewalks are not available. They're in disrepair. There are gaps between this particular side of the road from Market Street to Cedar Street, with some sidewalks being in front of the 4-unit apartment, and the rest of the gaps are not there. So there should be some thought given to how to address and come up with an overall sidewalk plan if this development then moves forward. Mr. Lynch also potentially raises a concern about the number of parking spaces to be provided. So with potentially 2 cars needed per 15 units, at least 30 spaces would be appropriate, but that doesn't even account for visitor parking. So one option could be to reduce the number of apartments as part of the plan, which would reduce the parking requirements. Another option could be to look at arranged shared parking arrangements with the adjacent development, which this particular party, Xavier Capital LLC, under a different LLC, owns the 4-unit apartment as well. And they do apparently have some degree of excess parking. So that's one possible solution, and the Planning Commission is authorized both to grant parking relief and to require additional off-street parking under 23059F. So in addition, as part of the review process of this particular plan, we do recommend that the applicants need to demonstrate some compliance with stormwater management regulations, and we do rely on the county for review of stormwater management plans. So that may or may not modify the final design of the plan depending on that aspect of the review process. They should also evaluate any impact on existing stormwater discharge from structures currently in the vicinity of the site, such as the stormwater pond that serves the Cedar Point subdivision, or any underground culverts or drainage pipes that go under the Old Virginia Road to the side ditch, which then empties into a larger drainage structure, stormwater pond. So their impact on any other existing drainage conditions should be considered and evaluated as well. Final master plan should show utility connections. We need to verify there's adequate sewer and water capacity at the site. Water and sewer impact fees would obviously have to be required for connection to the city's utilities, which is normally handled through the development process, the building permit process. It does appear they can meet trash pickup requirements for a on-site dumpster, which would be screened and possibly secured. But again, I think sidewalks are an issue here, and there should be a plan or some overall strategy that addresses at least those sidewalks between Market Street and Cedar Street. The other point I make is that the proposed plan at its density of 15 units on 0.584 acres could be considered in excess of the density limit of 25 units per gross acre as identified in section 23059C. So on a prorated basis, then the maximum number of units on this particular site, given the acreage, would be 14.6 units. So are they over the limit? Possibly. At 15 units compared to the 14.6 prorated standard. But the same paragraph goes on to state that the Planning Commission, Mayor, and City Council may approve density exceeding that which is permitted in the R3 zoning district upon showing good cause and benefit to the development and community. So it may be a matter of interpretation as to whether the Mayor and City Council desire to grant density relief or whether the 25 per unit standard is an absolute maximum limit. Likewise, on the open space requirement of 25% of the total land area, exclusive of parking spaces and roadways, the plan would need to show approximately 6,360 square feet of recreation area. That would be equivalent to about a 60 by 100 foot area. The concept plan shows 1,480 square feet, but the same paragraph goes on to suggest that the Mayor and City Council can accept in lieu or a fee for all or part of the required open space. And I think in discussions with the developers and staff also supports the proposition that a 25% standard is probably excessive. That basically concludes my staff report on this subject at this point in time. I'll entertain any questions. We do have the representative from the development team and his engineer here as well.
Madam Chairperson, may I speak before the developers come up? Good evening. I actually went by today, I went by a couple weeks ago, right after the mayor and council meeting that we had on the, what was it, July 7th? When the developers came forward, and I actually went out there today to reassess the sidewalks. The sidewalks where we're talking currently, where their current location is, that is no fault of theirs. That needs to be corrected by the city. They should not be held accountable for that portion of the sidewalk. It was not repaired after some repairs were done by the city officials, so that is something that should be on us. As far as Old Virginia Road, just to update, Old Virginia Road is mainly county, not the city. With that being said, there was an incident that occurred during the school year that the Pocomoke Police Department and Worcester County Sheriff and also Worcester County themselves actually got involved because someone almost got hit. It has come to the point where Worcester County will actually they're going to put sidewalks, and they're actually going to update the crosswalk before the beginning of this upcoming school year. So a portion of that will be corrected. Also, the Cedar, going back down Cedar, the police department has also, our Pocomoke Police Department, which they have already been ordered, they're going to put flashing signs up, to slow the speed down. So that will actually help deter with some of the speed, some of the traffic. So I'm hoping with the sidewalk complaints that's not going to be held against them. That will be repaired, and that is part of our update to the sidewalks in our construction and in our fiscal year 26 budget.
Thank you, that's a great update, thanks, appreciate it.
Good evening.
Hi, welcome.
Thank you.
Sorry to keep you waiting all this time.
No worries. No worries at all. Let me pass out a couple of exhibits here. pleasure to see you all again. My name is Keith Ayatt. I own Ayatt Architecture Engineering in Salisbury. I am here representing Mr. White and Mr. Xavier, who are the principals of Miles and Main Property Group. They also are the principals in the adjoining 6-unit apartment project immediately west of this site. And we have pursued, Mr. White and Mr. Xavier are the contract purchasers of this property. As you know, the property is currently owned by Sandpiper Energy. They came to me with the idea about creating an urban infill opportunity for this site, and upon reviewing the site, it made a heck of a lot of sense what they're proposing. The fact that we're close to the site's close to the high school, it's close to services vis-a-vis Market Street, it's easy access to Market Street for southbound travel. It's kind of an ideal location for an infill project. These projects do have significant expense associated, and the ancillary expenses are sometimes difficult to even anticipate. So the density of the 15 units is crucial to the viability of the project. And so we would respectfully request that if that density, where it's the 14.6 units per acre, as opposed to what we're asking for, which is slightly, if it was the 25 units per acre, we're asking for slightly over that 14.7 to go to 15. Our hope is that would be considered kind of a de minimis overage. As to the volume of the amount of parking, the adjoining property, again, that has sufficient coverage that we could dedicate 3 parking spaces over there, potentially, if that's the consideration of the Planning Commission. There's going to be a shared use agreement with that property anyway, because what we're talking about is looping the roads through. So right now, that property has a single exit onto Old Virginia Road. When you look at the site plan, you see that we're proposing an entrance on the Market Street side, and then the entrance comes through here. This would actually link through, and so that gives both properties essentially 2 means of access onto Old Virginia Road. So even though those are different ownerships, there will have to be a cross-use easement that would be recorded, and it would run with both properties where they would have access to that. So I think that the considerations of the traffic might be ameliorated by the fact that both of the properties would then have 2 accesses on Old Virginia Road. Having studied the site, yes, in the morning there's some backup. In the afternoon there's some backup, but for the most part it's a relatively lightly traveled road. And that is kind of the nature of the infill development, is you add some additional parking, but that's kind of the trade-off for being able to take away a propane tank farm. As to the sidewalks, that was lovely to hear from the city manager. Certainly whatever is done in terms of where the sidewalk lives, is it in the right-of-way or is it right behind the right-of-way? Whatever is determined for that stretch, obviously we will comply with that and would love to be a part of that process with county roads to make sure we've got consistent widths, consistent accessibility approaches and things like that.
If you remember, not to interrupt you, but if you remember our last conversation at our last meeting was, the sidewalks were a heavy hitter.
Yes, and they are shown on this plan. At this point, I have them shown at the edge of the 40-foot right-of-way. If that is not the case, if they're inboard of the right-of-way, then certainly through the rest of the parcels, then certainly we would align with those. Yeah. So we certainly will stipulate to the fact that we will provide the sidewalks that are consistent with whatever sidewalk master plan occurs. There are next steps here. Dan's discussions about the stormwater are well-founded. This is the point in time where the developers start to spend serious money. And so surveys, environmental assessment, things like that. And the soonest we will get a survey is about 6 weeks. And after that, then we can do our concept stormwater design. So I won't be darkening your doorstep anytime soon. Because we need to, from this master plan, we need to then be able to take it to the concept stormwater approval, which we can't do until we get the survey. But before they spend or commit these additional funds, it would be very nice to have it's not an approval, but at least an impression from the Planning Commission as to what your thoughts are as to the project, you know, before things really get serious on their end. I guess we're looking for just a feel whether you think this is viable, whether you think this is a good use for this project, whether you think that this is a good opportunity to start to develop some of the housing stock in the city of Pocomoke.
On the 14.7 versus the 15 on the units,
Yes, ma'am.
if it were to lessen, if it were to be less than the 15, where does the developer stand on that? Does everything go away?
I'll have to let them address that.
Mm-hmm,
So,
yeah.
Would you want to go ahead and address that?
Yeah. So 15 is really where we're at. If we have to lessen it, then that definitely it makes it not a viable project at all.
Mm-hmm.
So that's where we are, and it's what 0.3, what is it, 0.33 less. So I'm not sure. I mean, that would hopefully you all would give us a little grace and.
Yeah, I was just curious as to
Yeah,
where.
yeah, but yeah,
where
it
your
definitely,
flexibility was. Okay.
yeah. Were you finished?
Yeah. Oh. So unless you have anything else for me,
No, it might bounce between the two of you.
okay,
Yeah.
we'll go ahead. Okay, I'll let you.
All right, cool. So just a couple of things. We started reviewing the staffing report last night and earlier today. Just wanted to make a couple of comments starting off. So first of all, I want to say that we're actually partnering with Pocomoke. That's our intent, to partner with Pocomoke, not develop within Pocomoke. So if you understand what I'm saying, we want to work with you all to make the city better. That's our approach. We're not just here as one hit wonders, or we're here to make the city better. One, and in the staffing report, Dan, I didn't get my comments back to you, but we're actually developing 2-bedroom, 2-bathroom units and 3-bedroom, 2-bathroom units. The report reflects 1 and 2, 1-bedroom, 2-bedroom units. Another thing, we currently own the property that we own that's adjacent to this area. It's actually 6 units and not 4. And then to go back into the staffing, trying to get my notes. I was making notes as we were going along. As far as the parking spaces, the property that we have now, they have 2 spots per unit, and they're often empty as well. So I mean, we're not necessarily we're not pushing back on the two units or 2 parking spaces per unit, as the code reads 1.5 per unit, but we have exceeded that with 1.8 parking spaces per unit. So, but we also understand that we're increasing parking, and there's a concern with the congestion that it may cause. What else did I have? A few of the comments, I wasn't sure whether with the Worcester County, will the decision per the code be made from the city, or is it going to be based solely with the Worcester County Public Works. I'm not sure how that works when we get into design. I'm just, and I ask that because I want to make sure that our requirements aren't continuing to, where kind of like scope creep or become desirements. So we're just trying to protect our budget because budgets get busted like that. So that's another one of my concerns or our concerns.
Can you say that one more time?
The,
Repeat what you
okay,
said.
so as far as the design, the comment from Worcester County Public Works, I understand the actual road comments, but as far as the parking and things of that nature, in the design, it says or from the notes, it says we have to go back to Worcester County and get their concurrence or feedback on our design. So I just want to make sure who's going to be the authority for approval. Is it Worcester County, or is it the city of Pocomoke, or is it a collaboration?
In my opinion, since that is county road right-of-way, they're gonna have a say-so on that driveway design. So that's gonna have to be reviewed and approved, I think, by the county road department. As far as the parking issue, that would be entirely the city matter.
Okay.
But the road, the driveway entrance, and any congestion potentially that they feel could result on that road segment, could be an issue that the county, will have to weigh in on. And it's not unlikely in many situations similar to this, certain jurisdictions have required a traffic impact study to understand the impact of the development. Because you have a situation with the school and the school congestion, especially during drop-off and pickup hours, I think that's the concern that I'm hearing about along that stretch.
Yeah, we concur with that. We concur with looking at times of days and things of that nature. So it was just more so the interior, off of the entrance. So the parking, that was a concern because I'm like, can anyone just come in and dictate the code, or is it just going to be the city making that decision?
But as Dan said, it would be the city, once you come, let's say, once you come onto the property, then it's the city. In the transition from the county onto your property,
Correct.
that's what it's going to be for the county.
Right. That's all the clarity I needed
And
on that.
that's the way that I always interpret it, being as though that's Old Virginia as a county road.
Okay. I appreciate-
What was the part of having the two entryways coming in for an easement for like a little access road or something, to have two entrances? Did I understand that properly?
So
To eliminate,
Is there a current one over here for the existing one?
so, and
right, I have that.
the entrances would be linked. There would be a cross-use easement between the two properties. So people could get out here from
Okay,
this
that's
property,
right.
could get out the original entrance. In the 6-unit project, they could come through here.
Okay.
So the loop traffic patterns help dramatically with congestion.
Okay.
And
That's right.
when we take it to the next level, we'll certainly have all of those exhibits that we'll share with county roads. So I think that would alleviate those two entrances where essentially each property would have access to two entrances as opposed to singles. And it helps with the vehicular circulation through the sites as well. So, but I think that would help mitigate some of the congestion. We don't want people, and if there were signage, right turn or outbound, left turn only between the hours of 2:30 and 3:30, that sort of thing, I think that can reasonably be accommodated.
I certainly had that living in the city, when school was at
but-
7 and just
but-
everything turned around.
But anybody that's a tenant there, good possibility, they have a kid in the school, or they certainly know there's a school there. So and it's kind of the nature of the beast.
Right, so basically, this whole development is going to hinge upon your 14.7 versus your 15 units, right? That's the bottom line. Right?
Right, yep. And another question, as far as we talked about the final master plan should show utilities. How soon, will there be a fee incurred for this assessment? And how soon could the city, and I'm not sure who asked that, soon could the city come out and assess the utilities, so that we're aware of this?
So we have the water and sewer plans for this part of the city. So we know where the water is, we know where the sewer is. Ultimately, we'll engineer all of those connections. That's something we hadn't discussed, but we have access to all of that information. So we would be working with the city of Pocomoke, and also with it's the nature of the design process. At this point, we're trying to create
Nature of the beast is like, as we call it,
Yeah.
right?
But you've got plenty of water and sewer capacity in that street that we can get to. So
That's all I had, unless you all have additional questions for us.
I don't have any more questions to. So basically, what you need from us is just a consensus that, from the planning commission, is that right, Mr. Brennery?
Yeah, I think it's appropriate to give support for the project if
Yeah.
it feels necessary to move forward with it. Again, I think a key hurdle is to get county approval of that intersection driveway design. That is a key hurdle, because if they say no, we cannot approve it because of various reasons, such as congestion or whatever, then I think that's a major stumbling block for the city, to consider moving forward with it.
we'll certainly stipulate the fact that we have to do what we have to do to get county roads approval. But as a practical matter, the county roads cannot deny us access to Old Virginia Road. So we'll come up with a design that meets their needs, and I think looping the roads looping the entrances will help mitigate some of those. But county roads can't deny us access to Old Virginia Road.
Yeah, that's very true.
Yeah.
You already have access there.
Right, and we have two accesses. So we're getting rid of one of them because there's a loop where they took the tanker trucks, looped through the site. So we're actually making it better than it was. But I'm confident we'll be able to come up with a solution, that meets county roads approval. I have no concern there.
Yeah, I certainly don't have a problem with it. I'd like to see it move, to the next level.
Okay.
Certainly have my support on it. I just hope that you don't have too many hair-raising experiences with, when you start getting into the nitty-gritty of it. In my opinion, anything dealing with traffic in the county and the city,
There's the brain damage associated with these kind of projects. It's just the nature of the beast.
yeah,
And so the other thing we're looking at, and we may have mentioned it last time, we're doing an environmental study because there were tanks there. So we're already invested significantly into the project.
I knew you had mentioned
So,
that.
I mean, we're serious about it. So, we appreciate your.
So do you have another engineering firm that specializes in that, or do you go through MDE strictly for that?
No, we're using Hillis and Carnes in Salisbury. So they're actually gonna be performing our.
I got you.
In the next 45 days,
Yeah,
we should have the
they're good.
report.
No.
Yeah. So we'll be using them, and then the survey, as Mr. Iyett said, will be in 4 to 6 weeks, something like that. We'll have that, and we're using local surveyors as well. So, like I said, we're vested. So.
Yeah. Well, how does the rest of the commission feel? Are you supportive and you would like to see this project and development move forward? Working out the kinks as they go?
Yeah, I don't have no problem with it at this point.
I think staff's pretty much said most of our concerns as far as, especially sidewalks, that was a big thing. I mean, our standard for parking lots might not be the same as the county is mentioning here, so, I mean, we go by our standards, not theirs. I don't see any real issues with it besides the 4.6, but we may be able to work something out, see how it goes.
Yeah, but just to initiate, it sounds like you've got full consensus from planning and zoning,
That's,
so far.
That's all we can ask for at this point, and I appreciate that.
Yeah, I mean, we're here, and, you know, the city is obviously here. The city clerk and the deputy city manager, they're very easy to work with, and, Mr. Brandy, we, of course, is available to you. So, we look forward to having you back.
we appreciate it.
Very good.
We're looking forward as well.
Yeah.
So as far as milestones, our next milestone, and forgive me, what is the next?
That's gonna, I'm glad that you, yeah. I'm glad that you asked that. Mr. Brandy, what is, gonna be the next, step, the next level
Well, I
that we're
think,
gonna take this to?
You know, as we mentioned, I think two or three key things is, can you meet stormwater regulations, and can you get approval with the driveway design from the county? I think those are real key. You can move forward with that, you should be able to have a final design then, pretty close to final submission then.
And that's where I think we are, that we would have, the next time you'll see us, we'll have concept stormwater approval, which is key to something like this, because we need to make sure, obviously we have to maintain all of our stormwater, and convey all of our stormwater in accordance with state regulations, and we understand that. The other area that was in question was, and I forgot about this, was the 25% active recreation area.
Right.
And just by way of example, the building footprints that you see are 5,600 square feet. To have 25% of the site at 6,200 square feet, that would be more active recreation area than the footprint of the entire building. So I think that I'm not sure. There's a possibility that when that standard was written, it was anticipating much larger parcels. But I think certainly for an infill site like this, that's a parcel that.
Do you have a recreation area for the 6 units down at the, no? Because that's all the,
That was built in the 70s or 50s, 50s or 70s, I can't remember. We'll have to go back and look at the documentation, but.
I wasn't quite sure, you know, at the end, what I call the west side of it.
No, we don't.
Because
That
all
was-
that brush and everything
Yeah,
else that's
that was an
there.
entrance they were using for the underground gas tanks.
Oh, really? Oh,
Yeah. So, but we've since closed that off.
okay, that's what you did, okay.
Yeah.
Okay.
So what was the current percentage that you have on the blueprints here?
So it's at the 1480. They said there wouldn't be math. That's Scotia over 6%, 7%, 7. And I can. That's pretty close to the Worcester County standards. You know, in terms of PRDs in Worcester County, and I could get Dan that standard in Worcester County. They have, the Worcester County Code stipulates percentages of active recreation area based on the parcel size, net parcel size. So I could get that information to Dan as a comparison. But when you look at the footprint of like that active recreation area, we thought we probably have, you know, barbecue grills out there, something like that. Maybe some children's play areas and those kind of things. Obviously, 15 units, there's only so much you can do to underwrite those sorts of expenses. But that was at the very least we would do like barbecue grills and things like that. So. Yeah, dog park. But we'll certainly the next time you see us, we'll have a better definition on what that is going to be. But from a physical standpoint, it's difficult to see allocating much more space than that to it.
What kind of time frame are you looking at to be able to come back before?
Well, if we're 6 weeks out on the survey, 6 weeks out on the environmental, 6 to 8 weeks on the survey. So 3 to 4 weeks, to do the concept stormwater submission, to be able to get that into Bobby Shockley. So we're looking at toward the middle to the end of September, before we're ready to come see you again.
All right. Okay, well, you've got our support.
Cool.
Yeah.
That's all we can ask for. Thank you.
We have your support on the 15 units.
You know what? We can make the recommendation to mayor and council. Let's just say 15, that they may, we purely make a recommendation to mayor and council, and they in turn can take it in any direction they feel. We may say, we recommend the 15, and they may say, no, we're not gonna do that. Even though I understand what you had put forth at that point.
Right.
And for them to, not take into any kind of recommendations that we may have, that would kind of,
You don't speak for the mayor and council. I understand that.
Yeah, but I
Yeah,
We
know.
understand that.
Yeah, no,
But I
I was trying
understand.
to.
I know,
And there's
I know.
nothing wrong with asking that, because
Yeah.
I understand with you, putting X amount of dollars out and you're moving forward with what you have to do, and for us to make a recommendation to them and for them to say, no, I think that we would like to stay with the 14. But with guidance that we receive as a commission, I think we would pretty much have a feel for it as well. So, maybe by the next time you come, we might have a different feel, as far as a consensus maybe. But we can't speak for them, we purely make a recommendation, and we'll see how it goes. The mayor and council are very supportive of their commissions, so I would hope that would continue for many years to come.
Yep.
Okay, but there's no guarantees in life, right?
No.
All right, well, we appreciate that.
Okay.
Appreciate your time.
Very good. Thank you very much.
Thank you.
Have a good evening.
Take care.
You too, and thank you so much for waiting.
No problem.
Mr. Brantley, we're gonna hop down into old business for Robert Villas.
I did speak with Mr. Davis, one of the principals of the firm that's looking to purchase that development. He is seeking some additional financing, so that's where it's at right now.
He's taking a what?
He's looking at additional financing, so he's still working through. He says it's still a project that's moving forward. He gave me the indication that he would be presenting possibly something this summer to come back with as far as moving forward with the plans. As a reminder, they did receive preliminary design approval. We have recommended a developer's agreement be put in place. I do have one drafted up that says what their obligations are, the timing, and so forth. And I'll circulate that within the next week. So as far as I know, it's still a go project.
Just not on the timeline that he had originally hoped for.
Yeah, I think they're looking at a different
Yeah.
bank to secure financing from.
All right, just bouncing down to item number 2, fairgrounds wetland violation.
I don't have any information on that. Ms. Matthews, do you have
I
anything on that?
think I pretty much, after watching the Fair Board, then they addressed it, but go ahead, I don't think the other two have. Where are we?
Just for update for the planning commission, right now we are currently in the planning and surveying stages. So once that's been completed, survey has
We're in the what stage? I'm sorry.
planning and surveying. So they have actually already surveyed that area. So now they're working on a planning concept, which has to be submitted to MDE. So once that has been submitted to MDE, MDE will then approve that plan. But that's where we are right now. And if anyone did listen to the Fair Board meeting, the dirt piles that were there have been leveled down per MDE to make sure that they were still within the 25-foot buffer.
Is this all due to that critical area map? Or that pond that goes through?
Going on to item number 3, the comprehensive plan update.
Well, staff would recommend the planning commission set another work session date to continue their review of the chapters. There is the community facilities chapter that we still need to circulate to other staffs and other departments to get their feedback on. I'll try and send that out this week, such as the sewer capacity and numbers related to our utilities. But with that, the planning commission needs to continue to review the chapters. My suggestion is, if you have thoughts or changes, write them down, and after the entire review is completed, send them on to the consultant, so we're not getting stuff back and forth that have to be re-reviewed. I would recommend just reviewing, write your changes down, and then send them to the consultant as you complete your reviews of the chapters, and that he complete one overall revision to the document instead of going back and forth on each chapter.
Next item, the approval of minutes. I think maybe what we'll do, does anybody, do we want to set a work schedule, a work session now?
For the comprehensive plan,
Mhm.
do you like to maybe circulate this with the other members of the
Yeah,
board before we decide on the date?
We'll look at the calendar and see, and then check with Melinda to see what's open. That's gonna be the first thing to do anyway, to find out what's available, and go from there. Okay. Do we have the minutes of March 19th and April 16th, May 29th, June
The
12th?
minutes cannot be approved because Chip was here and this gentleman was not, so you have to have somebody here. who is
Oh, okay,
two minutes.
okay, all right. Of course. Any public comments to the commission? Before we adjourn? Do I have a motion to adjourn?
I make a motion to adjourn.
Second? All in favor? Aye. Unanimous, unanimous. What time is it?
Hey, 7:31.
My head.
I said an hour.
You said hour, thank you so much, that was all.